In this video, I'm going to be talking about carrying a handgun without a license in Indiana and what to do if you're charged with this offense. For a lot of people, you may not be sure about what you should be doing if you're charged with this, or what you can even expect through the process. And what you find out is that by doing your homework early and researching and learning about your case, you can help yourself get a better outcome in the end. So about me, my name's Nathan Vining. I'm a criminal defense attorney here in Indiana, and I represent individuals in criminal cases throughout the state. By the end of this video, you should know more about carrying a handgun without a license in Indiana. So with any criminal case, one of the first things you should do is look at the statute that you're being charged under. In Indiana, carrying a handgun without a license is regulated by Indiana Code 35-47-21. And what it does is it prohibits carrying a handgun in public, whether openly or concealed, without a license. This statute does not apply to rifles or shotguns since a license is unnecessary for carrying those. So if you plan on carrying a handgun, it's important to get a license. To obtain your license, you need to apply with the Indiana State Police. You should complete the license application online. Then you have 90 days to have your fingerprints taken, and you visit your local police agency with your fee payment and handgun license application number. If your application is approved, you will receive your license in the mail. If your application is rejected, you'll receive a notification in the mail along with instructions on how to appeal the decision. So what do you do if you're charged with carrying a handgun without a license in Indiana? The first thing you should do is look for possession issues. The state needs to show that you were in possession of the handgun. So there can be cases where there's multiple people around a gun that was found concealed. The state has to prove that you were the one that possessed it. Or there can be issues where you could be found with a handgun in a vehicle that's not on your person. Here, the state needs to show that you had control of the vehicle where the weapon was found, but they also have to show that you had knowledge of the weapon's presence. There's an intent element to the statute. You had to knowingly possess the firearm. So if the firearm is found in a vehicle, the state has to show that you knew the firearm was in the vehicle. So some of the first defenses in a firearm case is to really look at possession and intent to see if the state can prove those two elements. Another place to look in a gun case is search and seizure. Maybe there's an issue with a traffic stop where the police found a firearm that could result in the suppression of evidence. What this means is you have certain constitutional rights. You have the right to be free of search and seizures. So if you can show that the state violated your constitutional rights when they found the firearm, you could move to suppress the evidence. And what that does is it would keep the fact that a firearm was discovered out because your rights were violated. An example of this would be being pulled over for an invalid traffic stop. Or maybe it was found in a search of your home, but the police didn't have a warrant, and there was no exception to a warrant requirement found. In those instances, you could move to suppress the evidence. Another thing that I recommend if you're charged with the misdemeanor of carrying a firearm without a license is to try and obtain your license by the time you go to court. This won't make the charge go away, but it can help with the negotiation. It helps to be able to go to the prosecutor and say, this person made a mistake, they do have their license now, and the act that you're now charging them with would be legal for them to do now. So it doesn't make the crime go away, but it can help show the state that this isn't going to happen for you again, and it shows that you're trying to take the right measures to do this responsibly. So if you're caught with carrying a handgun without a license, the penalty is a Class A misdemeanor. There's no difference if you were carrying openly or if it was a concealed carry. In both instances, it's a Class A misdemeanor. And a Class A misdemeanor carries a penalty of up to 1 year in jail. The penalty increases if you carry a handgun on school property or on a school bus, or if you've previously been convicted of carrying without a license, or if you carry a handgun and you're a felon. There are also certain classes of people that are prevented from carrying a handgun. If you've been convicted of a felony in Indiana, or convicted of a misdemeanor or felony of domestic violence, then you can't carry a handgun. It's also important to know that you can have your rights restored and be able to carry handguns again. It can potentially be restored through reducing your felony to a misdemeanor. There's a certain period to wait, 5 years, if you've been convicted of a domestic violence misdemeanor and cannot carry a handgun because of that. Or you can get an expungement of a felony record and potentially be able to have your firearms rights restored. Another potential outcome in a case like this is what's known as a pretrial diversion. A pretrial diversion is an agreement with you and the state where basically you agree to stay out of trouble for so long. Sometimes you have to do community service, pay a fine, and do other requirements as the state sets out. But if you do those things, the state agrees to dismiss the charges against you. And that can help you preserve a clean record and keep this offense off your permanent record. Another possibility could be probation. If you're charged and convicted of a misdemeanor And a lot of times in Indiana, you end up on probation and you're monitored by a probation officer and have to follow certain requirements like not consuming alcohol, staying out of trouble, staying employed, and potentially doing community service. In the worst case scenario, depending on the facts of your case, could be jail. A lot of times you don't see people going to jail for misdemeanors for a whole year, but it can happen. It depends on your record, it depends on the facts of the case, and it depends on the judge and the court and the county you're in. So if you're charged with this offense, it's important to hire an attorney. You want to preserve your record. You want to look for the best defense possible to see if you can defend the charges, and you want to work to get the best outcome in the end. So if you have questions, give me a call. My name's Attorney Nathan Vining. I'd be happy to review your case, look at the evidence, and see what I would do in your situation and help you develop an appropriate strategy. So you can call me or text me at the number that follows, and you can also view more videos about the Indiana court process online.